Welcome, everyone. We are at the Charleston Gazette-Mail candidate meeting with West Virginia Supreme Court candidates, Division 2. This will be a question and answer session for the candidates with the editorial members of the Daily Mail Gazette opinion page in Charleston Gazette-Mail. I am Kelly Merritt, Daily Mail opinion page editor.
Bill Candler, State House reporter.
Gordon Moore, I'm the executive editor.
I'm Dawn Miller, I'm the Gazette opinion page editor.
I'm Chris Dorst, photographer for Gazette Mail.
And we would like we'll start off with each candidate having about a minute to say who you are and why you're running. And we'll start with Mr. Douglas and go from there. Mr. Douglas?
My name is Jim Douglas. I'm currently the family court judge in Kanawha County, 11th Circuit, 5th Division. I've got 42 years of experience in practice. Majority of that is in family law. The reason I'm running is with the departure of Robin Davis and with the eventual departure of Chief Justice Workman in 2018 or 2020, the family court or family law issues will not be adequately represented. I'm running because I believe a former administrator just recently told me at the Supreme Court that 1 of 2 cases that are filed in the Supreme Court are family law or domestic relations oriented. And nothing is more important than families to me and a family unit. That brings to me stability to society. We pay due deference to family law issues. That's not to say I don't have experience in those other areas, but we need somebody on the Supreme Court that's got family law experience because of the nature of those cases. And I've argued 40 plus cases to the West Virginia Supreme Court of Appeals. I think I have the experience to bring that family law prominence and accent, and this would be a predilection to the court. That's why I'm running.
Thank you. Jeff Kessler, live in a little town called Glendale. I'm in the Panhandle with a wife and 5 kids. I've been a practicing attorney since 1981, 37 uninterrupted years of practice. My practice is wide, general, and broad. I have done everything from adoptions to will contests. I tell folks not to handle people's problems from cradle to grave, whether it's representing small businesses, representing corporate clients, representing workers' comp injury, car wrecks, copyrights, you name it, I've done it. I've also had the experience of not only practicing law, even despite serving 19 years in the Senate, sometimes full time, part-time job, full-time work, you do it right. But at the end of the day, I still carry my phone with me, iPad with me, and took care of clients' problems. Whether that means going home on weekends and holding grandma's hand while we're signing a power of attorney and a will in the hospital, taking care of people's problems. And that's what lawyers do when they do it well. I'm running for the court because, quite frankly, I'm very concerned about the perception of the court and the politicalization of the court, quite frankly, that I perceive occurring. I assure you that if I'm on the court, I will be fair, open, and honest, treat every single litigant with respect, regardless of your race, color, creed, orientation, or power, or money. And you will get a fair shake when you leave the court. I think it is important to have this election, number one, because I don't want to see a stacked court full of appointees. The people of the state of West Virginia need to pick their court. That's the way the Constitution is. And I think that in and of itself will go a long way to restoring trust and confidence in the court. I am concerned not only the commotion going on in the Supreme Court, but how it trickles down to the circuit court level, the magistrate court level, law enforcement level. Quite frankly, I think erodes confidence in the legal system. That needs to be restored. I hope to do that.
My name is Brennan Long. I'm a resident of Putnam County, West Virginia, where I reside with my wife in Mount Calvary Baptist Church here in Kanawha County. And I'm here, I want to see integrity and justice restored on the state's highest court. Public's perception is that it's diminished as far as its faith in what our public servants, which is our justices, have done on our Supreme Court. So I'd like to restore that. I'm a former law clerk for Judge Blue in Kanawha County, also a former assistant prosecutor in Kanawha County. Started my law practice back in 2009. Practice in the loan office ever since I'm the founder of that. Do a lot of abuse and neglect, court-appointed criminal cases. Also have some personal injury, done some family court work as well as some guardian ad litem and some divorce and custody issues. But what I'd like to see done here in West Virginia is to have the budget more transparent, that our the voters they have a public trust in those that they put in office, and they deserve to know where the money's being spent, how it's being spent. Ask for their vote. Thank you.
Hello, everyone. My name is Denise Smith, and I currently live in Charleston, West Virginia. I'm from Montgomery, West Virginia. I've been licensed to practice law since 1996. I'm a court attorney, trial attorney. I primarily work in the area of employment law and workplace issues. I have experience representing employees. I have experience representing employers. I've also been an administrative law judge for Workforce West Virginia. And I've been an assistant attorney general for the state of West Virginia. My background is very varied and diverse. I'm used to looking at the law from both sides. I do not have one worldview of the law. I'm used to collecting all the facts before I make a decision, setting aside my personal opinions, making a decision based upon the law and the facts. I'm running because, like all of us here, we want to restore trust and confidence in the court. We are all concerned about the appearance that the court has been self-interested and with the misuse of public funds. And I think that can be rectified by, like Mr. Long says, having more transparency so that the voters know where the money is going and how it's prioritized, because no system of government works well in the dark. Second of all, I'm very concerned that the trust and confidence in the court is being shaken because of this process, and what the court is being very much politicized. When the governor appointed 2 career politicians to sit on the court strictly based upon their party, based upon their conservative values, that made the court a political institution. The first duty of the court, and it is a sacred duty, is that justices must remain unbiased and impartial and focus solely on the facts and on the law. And the public's trust will be shaken in a grave and dangerous way if we begin to see the court as being another political institution, pardon me. I don't believe that you should have career politicians sitting on the court from either the left or the right. They will have the appearance of being biased. The people cannot be assured that their case is being heard on the merits when we bring some people with political baggage into the court system. We're going to have situations where the justices currently on the court, if you're a career politician, you're going to have people looking into their record, looking into their voter record, looking into the statements they've made while they've been elected, what groups they've supported, what positions they've supported, and they're going to be subject to motions for recusal. Those are the judges that you accuse of being biased are the very judges that are going to be deciding if they are biased. So any decision rendered is automatically going to be suspect by the litigants. Secondly, if they do recuse themselves, the taxpayers are going to have to pay for another judge to sit in and hear that case.
I'm Bill Schwartz. I'm from right here in Charleston, West Virginia. I'm a lawyer who's been practicing for over 30 years, courts around the state of West Virginia. I have 2 boys, one at Marshall University and one at Capitol High School. I'm a graduate of Washington and Lee University, licensed in Virginia, School of Law, where my JD served as a justice on the moot court board, coached the regional champion mock trial team, earned my bachelor's degree from St. John's University. I'm originally from New York. My wife is from Princeton, West Virginia. That's how I wound up here. While at St. John's University, I was on academic and athletic scholarships, earning 2 medals in the Big East Championships, and earning the graduate scholarship for student athlete the year 1982. Since that time, I've represented mostly injured workers. I know what it's like to hold the hand of a widow and tell her everything's going to be okay. But I also know what it's like to handle a small business problem. Someone's just trying to get by. And all they want is fairness. This trip started for me. I've never run for office in my life. We talked about politicians. I've never run for class president when I was in high school. I try to avoid politics unless my practice is at risk. And I think the people's access to the court is at risk. I don't call when the governor has control House and the courts, tyranny, James Madison. We got a real issue. Back in April, I went to my 30th class reunion for Washington Olympic. And while there, I was the only West Virginia lawyer at the table. Man from Texas, who I knew for many years, points to April, Ms. Schwartz. How many justices are going to get indicted this year in West Virginia? And everybody laughed. I felt like they were laughing at me. And I thought his implication was, you're not really a lawyer from real estate, the real court. And that upset me. So I got back here, a couple friends approached me, asked me if I would consider running for the court. They caught me at the right time. And that's why I'm here. I was at Shiloh Baptist Church last night, talking about voter rights. And the pastor got up, and this cut through me like a knife. The pastor got up and talked to his congregation, and I was sitting over to the side. And he said, justice is not blind. She peeks. And that's a scary thought when people think that. Justice is not blind, she peeks. My word to those people and to other people, as my dad told me, voting is critical. Because you're at the table when you vote. If you don't vote, you're on the menu. You're not at the table, you're on the menu. And too many West Virginians right now are on the menu. I want to get them off the menu.
My name is Marty Shear. I'm a West Virginian by choice. I moved here in 1984. I took a job as an assistant United States attorney. I left that office with a special achievement award. I have continued to do some criminal work over time. I have represented people accused of killing 20 different people. I have experience with big ticket cases. I was in 2015, to bookend that, I was named the top 10 criminal defense lawyer here in the state. Meantime, I've also been a bankruptcy trustee, so I can tell you that an integrity issue, I think I'm the only person at the table who's had a federal background check every year for the last 5 years, for the last 30 years, since 1984. I think that bringing that integrity to the system is important. You bring personal integrity and you try to develop the court in that way. I was national president of the Bankruptcy Trustees Association. I was editor of their magazine. I've written a number of articles about bankruptcy issues, and a few others, but honestly, if I told you the names of the articles I've written, you'd go to sleep. But that's the work of the court. It's about details. It's about little cases. It's not always about murder cases. I mean, people talk to me about those cases, and I have those stories, but the day-to-day work of the court is about small issues. I spent a lot of time the last year examining the proper method for indexing liens at the courthouse. You might say, wow, I'd rather watch paint dry. But those are the kinds of issues that the court decides to do. So I looked at myself and I said, when the newspaper articles started coming out, am I qualified? And I started to talk to some of my friends, and they said, yeah. So I've achieved some notoriety, if you will, in the criminal lawyer. Achieved the bankruptcy area. I was named a super lawyer in 2009. I was asked to teach at the law school. I'm an adjunct at West Virginia University Law School, have been since 2005. And so there are a couple of different areas of law that I think I have reached out and achieved some level of success. I'm one of those lawyers who likes to know how something works, not just how today's problem gets solved, but how a lot of problems get solved. And so that's the kind of thing that we want the court to be deciding individual cases, but within the context of a greater whole. We're not going to make really big changes. I don't think the court should be politicized. So let me just say that I think it's about integrity like everyone else. I think that's something that I have a documented track record with, and that's what I think we
Hello, my name is Judge Will Thompson. I'm a circuit judge in Boone and Lincoln counties. Been there since 2007. Before that, I was a lawyer at Cook in Madison, West Virginia. I handled a wide variety of practices. I did a lot of appellate work. I did some work not only at the Supreme Court, West Virginia Supreme Court level. I was also working on the Fourth Circuit. My noteworthy minors pension case there. Grew up in Boone County, lifelong resident of Boone County, live in Madison now with my wife and 4 kids. And one of the reasons I'm running, one of the biggest reasons I'm running, and I agree with everybody, everybody's wanting to restore integrity and trust in the court. I mean, that goes without saying. I'm upset and angry with what's happened. Been a judicial officer since, actually, I've been a hygiene commissioner since 2003, circuit judge since 2007. I'm pretty widely known for a lot of my success with recovery courts, drug courts, teen drug courts, things of that nature. And the reason I think my drug courts are successful is I use a team approach. I use a lot of probation officers, day report staffs, things of that nature. At the same time, when this story is breaking about the couches and things of that nature, I'm getting letters and emails from the Supreme Court telling me I need to lay off people who work in my probation office that work in my. And that really made me angry. The fact that we can go out and buy $32,000 couches, but lay off staff members who are actually saving kids' lives, made me upset. I'm all about restoring the trust, integrity, the money issue. I think we do need to be more transparent. I have gone round and round in the Supreme Court, in which you don't really get round and round. It's you ask letters and they tell you no. I want to establish family drug courts. And I have to learn out, I've got 5 people convinced. I've got to convince 3 of the 5. I probably know as well as anyone which of the 3 justices that want to vote my way or vote against my way. But I don't always know for sure. So I think there needs to be a lot more transparency on the Supreme Court level, but not only with financial issues, but also administrative issues.
Hi, I'm Rob Frank. I'm an attorney from Lewisburg, West Virginia. First, I'd like to thank you all for inviting us here and allowing us to have a few moments to speak. I'm very honored to be with this group of great candidates. My background is a little bit different from the folks on the panel. I began my practice of law in Colorado in 1990 and moved to West Virginia in 2006. My wife decided that she'd like to be a physician and ultimately a medical school professor at WVSOM. In my 28 years of practicing law, I've had a significant breadth and depth of experience. What might separate me from some of the other folks on the panel is I've done quite a bit of civil rights and constitutional work. We're all going to swear to uphold the Constitution, and we're all going to mean it. But I've actually litigated First Amendment cases, association cases, speech cases, religious exercise cases. I've litigated Fourth Amendment cases, Fifth Amendment cases, Eighth Amendment cases, 14th Amendment cases. I've litigated federal preemption cases. All those types of cases are cases that are important, and they're important to the people of West Virginia. I've done quite a bit of work in pharmaceutical litigation. I recently tried a national bellwether trial relating to the prescription drug Risperdal in the California State JCCP. But on the other hand, I've also represented folks in family court. I've actually had the honor of litigating against Jim Douglas at the other end of the table. And that was a great experience. And I agree with you that whoever sits on the court has to have experience in family court matters. But I've also done catastrophic injury cases and easement cases. I've done cases regarding small businesses and financial institutions. I've done cases regarding securities litigation. I have a significant breadth of experience doing complex cases that I think the court needs. Appeared in the appellate courts in the 10th Circuit, in the 5th Circuit, in West Virginia. I've appeared in Massachusetts court, in Illinois, California, Louisiana, a number of other jurisdictions. It saddens me to think that the people of the state of West Virginia have lost faith and confidence in their Supreme Court. This court belongs to the people of the state of West Virginia. They have an absolute right to know that their court will be a court of judicial restraint, that their court will be a court which is open and transparent, and that they will have access to that court. Not only an opportunity to be heard, but an opportunity to be fairly heard. Thank you.
Thank you all very much. Obviously, everybody brought up what's going on, some of the issues that the Supreme Court has been in the news a lot for lately. But I want to start, the first question is, there has been a change, outside of this news, there has been a change in West Virginia Supreme Court in recent years in terms of some decisions made, and in terms of how it's regarded by a particular institution outside of the state. Tell me, what do you see? How has that change been in terms of decisions made by the West Virginia Supreme Court? How has it changed in the past 5, 10 years? For the better, for the worse, for the same?
Can you just clarify what institution?
Well, I'm talking about the American Tort Reform Institution, basically the Supreme Court being removed from the judicial hellhole list. So, somebody on this end had, Mr. Douglas?
I thought you were starting down here again, you know. I think the thing about me more about the court than anything else, and I've been a prosecutor, defense attorney, and special agent law, and a number of various things in 42 years. I think I've watched the erosion of the predictability function. I think that's negative. Okay. Can you do it again?
I think you're fine. Just
Predictability function. Yeah. You tip on that?
yeah.
Okay. Just up there. The erosion of predictability function, that means, in terms of people who are not attorneys, everybody here at the table. That means that when somebody goes with a certain set of facts before the Supreme Court, then the results should be predictable, that the law is going to be the same in each one of those subsequent cases. Once stare decisis, or once that precedent is established. And that's what I see is the Supreme Court lawyers, and particularly family law too, have abandoned that to be result oriented. Right. The second thing of it is, and that's another reason I'm running, is we're getting the connotation now to be on the Supreme Court that has to be millions of dollars placed into a campaign over a period of time for a 12-year term, at least a year. That's one of the better things about this short campaign is it levels the playing field, and you don't have to be extremely rich. I guess maybe poor, just jumping into it at the last minute. But what I'm saying is that I get the sense now that that long cabinet principle was so very much alive in the beginnings of the republic. And anybody could go from log cabin to be president of the United States. Incidentally, historically, James A. Garfield was the last one log cabin that went to the presidency. But nevertheless, I have to believe that we have access to those positions. And that's not the case.
Talking about the study, actually, one of the authors of the study came to start one of our judicial conferences several years ago. First of all, I think it was a biased study. Did not agree with all its findings. However, what I think we need to do, and I think the Supreme Court has done a few good things in the past several years. And what we need to do is we need to remove the politics from the Supreme Court. You go for a judge, or you go for 5 justices, whatever it might be. You should not know if that judge is left of center, right of center, Democrat, Republican, voted for Trump, voted for Clinton. It shouldn't matter. What should matter is the judge should call it straight down the middle. The judge should look at the law and facts on both sides. And I think we've seen that recently out of our Supreme Court. And I think that was probably, although I don't agree with the study, so it's probably I was part of the study when they looked at the entire system. I think our Supreme Court has done a better job, at least on that level, of trying to take some of the politics.
One thing I would like to note is some of these changes that we're seeing are also the result of court reform laws. I mean, as judges, we're not allowed to make up laws or strike out laws unless they're unconstitutional. So anytime that the people out there perceive that the Supreme Court is going in a direction that they don't want to, they should first try and work with their legislators to get laws instituted that they feel better suit them. And second of all, make sure that they vote according to how they want the laws to see, because we are, as a judge, that's not our job to create law or do away with laws unless they're unconstitutional. We are to apply and interpret laws.
You know, I'm concerned about the role that money has played in politics and how it's infiltrated, frankly, into the court system. When I first started in politics, 2 years ago or whatever, I mean, you know, you could run for state senate and $15,000, $20,000. Now we're spending hundreds of thousands of dollars. See people spending millions of dollars to be elected to the court, and these third-party groups will throw all this money out there to try to try to somehow or other control the votes of the public and to create a perception of what they want to believe. Do I think we're a judicial hellhole? No, absolutely not. If you look at the facts and the number of filings, the number of cases per capita, the turnaround, the speed, everything that's happened with the court, it's not true. It just isn't true. It was a very effective PR campaign in order to get the little old mom and dads and jurors that sit in the public to say, well, there's a big old crisis out there until it affects them, you know. And that's why I believe that I'm very concerned about the role of money in politics and how it's, again, as I mentioned, played a role into the court. I've never asked a client to walk in my door if you're a Democrat or Republican. I represented Republican chairmen and their families, and I take care of them. And I don't care about their politics. I care about solving their problems. And that's what politicians do. You know, people say, well, you know, I don't, you know, career politicians. I mean, that's an easy word to say that, you know, somehow or other it makes you sleazy or bad. Politics is public service. And when you do it well, and it is done right, there is no better calling, quite frankly. It's very similar to the legal profession. That's what you do. You help people, you solve problems, give them a fair shake, you give them an opportunity. That's what a judge should do. That's what every person should do. You know, I've been endorsed from the Coal Association of the UMWA. I've been legislator of the year from the ACLU. I've been endorsed by the NRA. You know, a broad spectrum of folks. And I've told a lot of them no over the years. And that's, you know, and that's what a judge needs to do based upon the fact of each individual case.
I think the concept, and I agree with, by the way, once again, I'm agreeing with a lot of what Jeff Kessler says. But the concept that judges don't make law, I wish it was true. Okay, there's a reason why millions of dollars have been coming in to West Virginia, our little state, to control our court. And it's not today, it's been going on for, you're talking to a guy who wasn't born in this state. I spent my adult life has been here. But I went to a national school, law school, and I have friends throughout the country who talk to me about West Virginia. And this goes back to Don Blankenship trying to buy this court. We have novels written about us. I consider that an embarrassment. And the purpose that they're spending this money is to make laws, to close the courthouse doors, to benefit certain people. I don't think Don Blankenship, when he spent all that money last time, got what he wanted. And the proof is in the pudding, because the judge who put it in, they want it out. And to say, that's the 800-pound gorilla in the room, to say that that doesn't exist, then we never address the problem, if we don't point our fingers at the problem. You know? So these judges who've been coming in, and the money that's been coming in to put judges in, the purpose is to get something. And the purpose is to put the majority of West Virginians on the menu because they're not at the table. And if we don't address that in some way, through campaign finance, I don't know, some way, then what that pastor said last night to his congregation will just get worse and not better.
Let me just jump in and talk about the campaign finance reform, because what Senator Kessler did when he was in the legislature is he promoted a system for public financing of judicial campaigns. We find ourselves in a situation where public financing is not available for this go-around because the legislature did not bother to appropriate any money, did not anticipate this particular problem. And so we have had a situation where it may be an even head start, as Judge Douglas said, but it's not an even playing field because, quite honestly, I was not planning on running for the court until fairly late in the process. And to me, it's about qualifications and it's about long-term approach to the law and the way that we rebut these improper influences that people have identified is by having people of integrity who say, I know what the law is, I know how it's going, decisions we're going to make are part of a fabric of decision-making that is consistent from one end to the other. And that's that's what people here have emphasized, the breadth of their experience, the knowledge about how the law works, and and an ability to express that in a clear way so that when you read a decision, you feel comfortable saying, I know how this case was decided, and don't feel it was decided because someone brought some personal agenda to the table.
I think that the ultimate gatekeeper, the ultimate decider who can really change the perception of the household, can really change the perception of focus of money in politics, is the voter. You know, West Virginia, in some ways, in my experience, is a unique place. It's the people's court. They get to decide. They get to listen to each of us, and they get to hear us talk about things like judicial restraint. They get to hear us say that the court should not be another branch of the legislature. And if we say that, and if we are committed to that, and if we do that, that's a frankly goes a greater way than any legislation would ever go to turn this around. But it begins with people committed to that concept of judicial restraint. Because as soon as the court begins acting as another legislature, it's distorted its function, and frankly, it can't do its job.
I've got to address this one thing, I haven't heard that, but this judicial hellhole thing. I'm Jeff Kessler. I'm so tired of hearing this. It's the same people that put millions of dollars into the judicial campaign that have been calling us a judicial hellhole. West Virginia workers do dangerous work. They die in large numbers. We are number 2 in the nation. Number 2 in the nation per capita, people dying of mesothelioma. Don't tell me that because somebody gets a multi-million-dollar verdict in a court in West Virginia where it's fellow, I trust juries. I trust juries to do the right thing. People constantly talk about out-of-control juries in West Virginia. Juries are the backbone of our society. I think it was Adam that said, without a jury, they could clothe us like swine and treat us like animals. And the whole concept, they work hand in hand. You got on one hand, we're a judicial hellhole. On the other hand, millions of dollars go into their big candidate. And the goal is to put us on the menu. And that's a gorilla in the room too.
I think,
Wait, Mr. Hall.
I agree. I don't think that those that support justice should have basically the votes behind that justice as far as trying to sway the court. We need, as a practitioner, when I'm sitting down with my client, I need the rule of precedent. I need to be able to direct my client because they're asking you, what are my chances to win this case? If you can't give them that, and to be result oriented, it's a lottery system. You don't know what you're going into, and that's not a good system for a practicing attorney. It's not good for the voters of West Virginia. It's not good for society in general. But we definitely, you can follow money trails. You can see where special interests get involved. And I don't think that should be part of the judicial system.
yeah, I just want to disagree with my esteemed colleagues up here about interpreting the law. That's what we should be in judicial restraint. I think philosophically, I'm in favor of an activist court. For the reason being, we would have never had Brown versus Board of Education of Kansas had there not been an activist law in court. We would not have had the Windsor decision on LGBT rights if there had not been an activist court. Current justices are the same Gorsuch and Kavanaugh. And, you know, and some of the human rights things that have been done, we had the activist court on criminal rights. So, former prosecutor, I'm a little bit more pro-defendant, but we would have never had those types of rights like Miranda versus Arizona if there had not been an activist court. So just to sit back and say we interpret the law, there are points that and times that the court has to take proverbial bull buck horns to correct issues that demand correction. Question?
I'm looking good. So, okay, let's change gears, talk a little bit about administrative stuff. So, electronic filing, we're partway there. So I want to know from you what kind of priority that is for you, what you would do as a justice to get it statewide, and public access. Public access includes press access. I saw the judge first. Yes, sir.
We are starting to do making electronic filing available throughout the state. It's has a lot of stops and starts because I don't know. There's a couple of different vendors that tried it. Seems like the vendors that worked didn't get the contract from the Supreme Court. I don't know why. We have, I know Boone County has put their files electronic access. I think it's very important. I think there needs to be a more unified system. I think the Supreme Court, quite frankly, has dropped the ball on it. It's not that hard in 2018 to be able to look at stuff on the internet. It is very difficult. You know, the program that we're running now, I struggle with, and I was one of those whiz kids back in 1981, you know, before the internet, you know. And it goes to public access, because I don't know how many of y'all have been to the Benton County courtroom. It's a beautiful courtroom. It's a 2-story courtroom, and I love history, and I talk to the older lawyers, and they say, you know, that was what, you know, back in the 50s and 60s, people did not necessarily get their news from the newspaper, television stations, even going back to the 30s. They would come and actually watch the trials. Nobody comes watch trials anymore. You know, it's not, and I guess it's part of the information age, maybe we're all too busy. So I think the more open the access is to the court system, to the public needs to know what's going on. There's lots of issues that are handled by our local courts, by our Supreme Court. Our Supreme Court does do a decent job of actually live streaming the arguments and things of that nature. We don't have to actually be in the seat. I do think we need to have public access. And that's being said, there's certain cases I handle, you know, abuse and neglects, things of that nature, that has to be close to the public. And there's really good reasons for that. But for your run-of-the-mill criminal case, your civil case, it all should be open. It shouldn't be hidden, and it should be open in such a way where it's easily accessible. When I'm sitting as a circuit judge and I'm having trouble accessing electronic documents, there's something wrong with the system. When I have to go, when I get frustrated, say, just give me a file, I'll run through the file. It's not very efficient, and I don't know who was the technology director at the Supreme Court. I'm not throwing him under the bus. But it does need to be done better, and it does need to be promoted access to the public, because of course, our for the public.
Yes, sir.
If I may, just briefly, I would agree with the judge on many of those comments, and quite frankly, I would also make it a priority. We do live in the 21st century. You know, these things didn't exist 10 years ago, but on the way in this room, I was reviewing a contract and sending it to my client, or to my secretary, to say, or assistant, to have them come in and sign here at noon while I'm sitting here. Couldn't be done when I first started, it was all paper. Marion County has electronic filing. I got a pleading with a motion to dismiss in a case I'm representing a company over there. And whenever I've been in the mail, today, I got this last Wednesday. You know, that's, there's no reason for that. You know, in today's day and age, it's knowledge is information, knowledge is power, and knowledge is, and information is critical to, a prompt and efficient use of the courts. We could get it implemented in a week. All I have to do is put my 13-year-old, 14-year-old conquered Fortnite, put them on, put them on the computer screen. But in any event, it's not that difficult, and it needs to be done ASAP.
Okay, yeah,
The federal government has gone to electronic filing pretty much nationwide. I do a great deal of work as a bankruptcy trustee, and so mostly that's the system I function in. The state system is somewhat different. Federal cases are almost all going to be open. Divorce cases are going to, family court cases are going to be sealed. Abuse and neglect cases are going to be sealed. Juvenile cases are going to be sealed. Adoption cases are going to be sealed. So there is some need to have those kinds of proceedings, and the electronic access issues are going to be a bit complicated. But it does not seem to be difficult to emulate what the federal government has done on the civil side and on the criminal side throughout the system. It has saved a lot of money. And I recall calling one courthouse where they said the computer was down, and said, I need to find some records, and said, system's down, there are no records, there's no backup paper copy. We have committed ourselves to this deal. So, and I know that with, I live in a circuit which has three counties and judges are moving around all the time. They want to be able to review cases where they are. And so if they're properly structured electronic system, that's easy to do. It's easy to schedule courtrooms where judges are sharing if you have some internet access. These are things that are part and parcel of the modern judicial system. When I practiced law, I used to walk to the courthouse. When I started practicing law, I walked to the courthouse and do some research in the library. The library's closed. I do my research online. When I come to work, I sit in the chair, I read email, I draft documents. I actually can file documents that don't exist because I can create them and put them on PDF and forward them to the court. So it's a radical change in how we become practicing law. It should be streamlined, but going from the place where we were to the place where we want to go is going to be expensive. It's going to require some monitoring. It's going to require getting it right. But there are people who've already done it and gotten it right. And so it's just a matter of, I think, copying it.
Yeah, I think you'd be hard pressed to find anybody who actually represents clients who doesn't want an electronic system when it comes to filing. You know, I was shocked when I came here in 2006 and there was not electronic, because in the jurisdictions that I practiced, both federal and state jurisdictions, it's ubiquitous. And there are many, many models throughout the United States that can be looked to, many vendors throughout the United States who have already done it. And it can be done here in West Virginia. And when you're sitting in front of a judge and you have a complex case with 200 or 300 plus pleadings in it, and you need to find out what the minute order was on January 2nd, 2 years ago, having access to that computer to be able to push a button and pull up document number 206 is just a godsend. And the people of the state of West Virginia deserve that just like everybody.
But the only problem in all that is that somebody manually has to enter those documents sometimes on the file. You know, they have to put the data in and make it accessible. And nothing's more disturbing to me and frustrating is when I pull up on the current system we have, come on, we don't have e-file, is to see that some document has not actually been registered in the existing e-system. It's called Circuit Express. So, you know, there's still a human element there that provides for efficiency.
I've been involved in representing Dist and asbestos clients for 25 years. And I guess we were the guinea pigs of the electronic filing system about 15 years ago. A typical case that I have, you may have a guy who worked at Carbide, DuPont, FMC, and he has, there may be 10 defendants who manufacture asbestos products at one place, and different defendants at another place. So you got 30, 40 defendants, one suit, one guy who got him, all filing pleadings, all coming at the court, end of your Since electronic filing, I think this is around 2000, May 18, it's been a godsend for us. I mean, I even told my secretary that as we were filing, we just press buttons and they're fine. And how do we do this? How many trees will we kill? The last time we were filing all these pleadings going back and forth. I don't know how you do any complex litigation in 2018 without an electronic system. Impossible. That's my 2 cents.
I think a couple of candidates have mentioned that the relatively short campaign period has urged them to run this time. And the issues come up with our going to the nonpartisan system, that the election of judges is a one-shot deal with during the primary election with no runoff in case no candidate receives a plurality of votes. Wonder what your thoughts are on possibly having a runoff election in the fall to select judicial candidates as opposed to the current system where it's a winner take all in the primary.
Starting on my end. But my feeling is, I believe it is the state of Louisiana that has a system that obviates the need for a runoff. I mean, there's nothing more expensive than to have to go through an election, then have to go through it again, second time around. But I respect the thought, especially since Justice Walker was elected with less than 50% of the vote in 2016. But Louisiana, coming back to it, my understanding, has a system where if there are multiple candidates, there has to be a minimum number of multiple candidates, like 6 or something like that. It's 2 or something, that's obviously. But if they have the multiple candidates and nobody gets a clear majority, then they take the bottom candidate, the bottom vote getting candidate, and then they split those votes up with the remaining 5, like in my example. So somebody comes across the 50.00001 yard line. And, that makes some sense. That way, nobody's votes are discounted, votes are used, and they don't use the way the vote is wanted. I understand that system is in place.
Do that once or keep going?
Keep going to somebody.
Until somebody.
Yeah, take the 5th one off until somebody crosses, unfortunately. So I think it sounds like a good system, and, that takes that money factor out of it. But it is kind of disquieting to see somebody, in this race, theoretically and mathematically, somebody with 10 of us miss with, 10.01% and then the popular vote. 10,000 votes, 1,001 votes with each step of the cap.
I'll just briefly, it's a legislative function, and surely it's not gonna come in play before November 6th, because otherwise we'd have to call the legislature back into special session. I don't suspect that's gonna happen. But in any event, it is a new system. It's our first time really, I think, with a nonpartisan election of judges. Let's see how it goes. Anything that creates more elections, I'm not so sure I'm crazy about that idea. Just, if you're gonna have partisan elections and primaries, then I think let's go back to the system where they're elected politically. But let's give this a shot, see how it works, and we'll go from there.
So the one comment I want to make is that having gone to nonpartisan election, I totally understand that from the judges. Difficulty is that the historical structure that supported elections, the party system, is not available really to us. It's not normally if you ran as a Democrat or Republican, you call the Democratic chairman in this county and say, hey, I'm running and I'd like your support. What can you do for me? And then help. That structure is sort of missing. And so I kind of miss it because it's left me a bit more of a drift. And the promise of public financing that probably would replace that is missing in this go around as well. So I'm not sure we'll learn that much out of this election process, but certainly having elections that make sense and people have confidence in it, people that have the idea that the person has majority support, certainly a great idea, but the mechanics are pretty tricky. This is an election. Normally, we like to elect people separately. This is probably the one election where you could put all 20 candidates from both seats in a hat and said top 2 vote getters get the seats. But that's not the structure that we would want if we had incumbents running or that kind of thing. So it is difficult to draft a rule that fits every possibility that you want.
Well, this race was kind of governed by statute to where they had to split it up into divisions, which has confused the voters exceedingly. Just going out on the road because people are like, what division am I in? And why did you use the word division? Well, that's the term that was used in the statute, so it's set up. I don't think that the drafters of this provision ever thought we were going to be in a situation like this. So it makes it a little awkward. But I understand the point of having a runoff, and there are good reasons for that. But I would also have some concerns that would, further increase special interest money because it would create a very expensive way to run, and then you're going to have more outside influence or special interest group influence that the candidates would be relying upon to run a race.
And this is a truly unique circumstance, this particular election. And that's an understatement. We sure hope it is. And I think the unique circumstances of this particular election are part of why you have so many candidates. You have essentially open seats with no incumbent and a very short window within which to campaign. And frankly, that makes it attractive for You know, people that don't have the large money backing, people that don't have the kind of name recognition of a established politician. So I think that this is a very unique situation, and I think to try to draw conclusions overall as to the system based on this election probably be misplaced.
One thing, I think I agree with Jeff Kessler that his legislative issue. One thing, but I understand having 10 people run for a seat is kind of difficult. One thing that could be fixed through the legislature is maybe have some type of petition process where you need to have some type of required number of signatures for each portion of the counties or congressional districts. I don't know what the best way to do it. But, you know, I do agree, 10 candidates, that's tough for a voter to make a choice. Hopefully this will be a unique situation. We won't be repeating this in the very near.
I appreciate these forums. I know when I'm out talking to the voters, they're very confused. They're asking, you know, what race are you in? Is it, you know, how many people were in it? What all is going on? So these type of forums, which I appreciate that they're having, is a way to educate the electorate. It's a way for the voters to at least get a snippet of each candidate and hopefully make some kind of informed decision. It's the best decision they can whenever they come out to vote. So I am very grateful for these type of meetings that we can have, and as many candidates that can come. You know, it's beneficial to the voters.
I think this is unique for very different circumstances. I mean, I keep coming back to the reality of the situation. Does anyone doubt that there are two incumbents, by the way? We are dealing with two incumbents recently. I believe, and I think this goes back to, I guess, I've been criticized for this and praised by other people, but part of my action against the governor, it wasn't the direct part, but how I felt about it, was the governor had an opportunity, especially given the new law we're experimenting with. He could have picked two people, two senior guys from firms who weren't running, and let the voters decide. That's not what happened. That's not, so this is not a good test case for how this works. It's got nothing to do with nonpartisan, it's incredibly partisan. We're the one people sitting at this table are the only ones who are tied with their hands tied. They can't tell who they really are or what they're doing. There's no one that doubts the position of the two incumbents that are going to be coming for about 30 days. But they do have an distinct advantage. So this test case of how this is not a good test of nonpartisanship. It has the only people who have to live by the rule of nonpartisanship are the people sitting at this table. And they're at a distinct disadvantage because of circumstances in this particular case. And I think it's a shame. It didn't have to be that.
This is the first nonpartisan race, though.
Yeah, 2016.
Yeah, it's been.
Yeah, Judge Thompson and I were the first one.
Yeah, I'm just saying, this is not a good test case. This is not a good case.
What you're saying, but just point of clarification.
This is an advantage, or they have to be stuck up in the East End while all of us are out meeting people. Yeah.
There's an amendment out this fall that would put the Supreme Court budget under legislative control. We all know why the legislature put that amendment on the ballot. Some people are worried that it's just one more way, what we have been talking about, for control be exerted over the court. Anybody have any thoughts about that?
Most of the budget is predetermined by you add up judicial salaries, you add up. I was a little surprised. I was asked earlier on what's the budget for the judiciary in West Virginia, and I said, I don't know, and someone said you need to find out. I was a little surprised to find it's $147 million last year. And I started saying, where'd that money go? Well, there's 74 circuit judges, there's 47 family court judges, there's 5 justices Supreme Court, there's 158 magistrates. They all have staff, they have expensive staff, we have books at libraries, there's some rental payments to a variety of places, we have a probation officer on that budget. I mean, there's a lot of money getting spent on the judicial budget. The amount of money that is not predetermined is very small. Now, I read it. Who predetermines?
Statute.
Well, the statute determines most of that. Now, there was a budgetary process that allowed for a huge surplus, $29 million, I think I read that. And that's largely been spent down, mostly, I'm told, on electronic, newspapers suggested on electronic filing issues, and that makes some sense to me. Now, there's clearly money that went astray, and And I think that a process that's more open, I don't have a problem with legislative control of what's open. But what we don't want to have happen, and I went up to Congress, we were bankruptcy trustees were lobbying for a raise. And I was up there and ended up talking to some congressmen who said, we won't give federal judges a pay raise because of this decision or that decision. And they can't cut pay, but we don't want an independent judiciary to be threatened by a legislature that's bent on exacting revenge because there was some decision made that the legislature didn't like or didn't want to. We need to just keep independence in the courts, so the decisions that can be made need to be made. They need to have the resources to make them. We don't want to start taking books away from judges to help make decisions in cases. But at the same time, some kind of cooperative feedback back and forth, having the Supreme Court suggest a budget that has details, I think is an important process. How deeply you're going to get into involving cutting and deciding, what that is. But I think it's on the, what we call the non-core issues. After we get rid of all the predetermined expenses, then we start talking about what we're going to really do. Because truth is, I read a comment from one legislator said, I'll be happy to vote for the 147 million. I'd just like to know where it was spent. In fact, that budget may need to go up, but they do need to know where it gets spent. Not only the legislature, but the people of the state.
I think the amendment's going to pass overwhelmingly given everything that's happening. And I don't necessarily have a big problem with that. And I understand there's a lot of predetermined, judges' salaries, magistrate salaries, things like that. But there's also things that are not so predetermined, such as drug courts, such as truancy courts, things of that nature. I would rather trust the programs I operate and I believe in right now. Legislature, in the Supreme Court we had 6 months ago. The reason why, if I have a program out to the legislature, we need to keep it running, increase funding, whatever it might be. I ran into some situations which I alluded to earlier, where if I didn't have 3 justices wanting to do my program, when I say my program, I mean programs are throughout the state. All they had to do is not necessarily say, we're not going to have drug courts. We're just going to cut positions from drug courts. We're going to cut, or we can't drug screen people in drug courts or things of that nature. We've got in trouble before because we've ordered too many drug screens. That's what we do in drug courts. So I think it can work. Now, I will tell you that with one caveat. I am very fearful that, say the Supreme Court makes a controversial decision, which they do, I mean, that's their thing, and that it gets the ire of certain legislators. What are they going to do? Well, we're going to cut your budget by 15% this year. So that's very scary, because where does that 15% come from? Because it doesn't come from salaries, it doesn't come from it. Then you see the program start to be cut. You see probation officers being laid off. You see electronic filing, it be put on the back burner. So I think it is going to pass. I would probably rather trust the budget with the legislature. The legislature is supposed to control the budget. It's the way government works, the way it works in 49 other states. But I am concerned that the Supreme Court budget could turn into another political issue. And there already is political issues. I mean, I've been on the bench long enough to go through a couple pay raise requests for circuit court judges. They're very political. I mean, it's.
You should be a criminal.
Yes.
They haven't got a raise.
They haven't got a raise since like 1990. 84.
In the family court salaries.
So I do think, I don't think my opinion on independent matters, so I think it's going to pass. But I think we need to be careful, and the legislature needs to be careful, making sure that they're not doing some type of retribution for some type of decisions.
The independence of the judiciary is important, but in the other places where I've appeared, the legislature does have control of the courts. I've not seen it as a problem, and frankly, I trust the voters of the state of West Virginia to make good decisions to where if they see retribution coming from the legislature, vote the bumps out. And I certainly hope that, and I certainly do trust the people of the state of West Virginia. And I like the idea, and there is a program such as increased supervision of sex offenders that needs to be funded. But the legislature has the responsibility of stepping up and funding that program so that it can actually be funded and actually be administered by the courts.
justice should be blind, but it is not free. And quite frankly, it can be quite expensive. The other 49 states have been mentioned that there is some legislative control of the budget. I'm not aware of any real outliers that have run into that scenario where they've actually cut the budget of the court so much that it's cut significant programs. But I tell folks, that there's three branches of government, obviously the executive, the legislative, and the judicial are separate but equal. But you know what? The judicial is a little more equal. Guess who gets to be the final arbiter of disputes of constitutionality that Douglas talked about earlier, that, cases that have been decided by the U.S. Supreme Court, Roe versus Wade, not Roe versus Wade, but Brown versus Board of Education, the REC decision that created separate but equal opportunity for access to all children, equal funding. Those were things where the court could say what the legislature was doing was wrong. The penitentiary in Mouthville was, unfit, and it was cruel and unusual punishment. So they would have the ability to say, this is an unconstitutional overreach into the judicial operation or the effective judicial operation of the judicial system in the state. So I think if you ran into that scenario, it can be stopped. That's why the justices have a final say over what's constitutional and what is not.
The last thing, I guess on the last one, the idea of this, in our republic, the whole idea of representation is that we have people in government, so supposedly they're making decisions for the common good. I realize that may be ideal, maybe somewhat fallacious, but nevertheless, I think I'm very much in favor of the amendment for two reasons. One is I'd really rather trust the operation of government to at least on the budgetary, the 134 people in the legislature to do the right thing rather than 5. And we've seen what happens when it's 5 making those decisions that are unaccountable. And the other thought I have is this, that it provides a unique opportunity for us this way. Because then we can fit things into that budget that are not only popular, but necessary, and it's going to put the legislature on the defensive if they For example, I still say like they have the business court division now, they have like mass tort litigations, things like that, aspects. Why can't you have regional drug courts using already elected justices? I mean, like we had that one pilot program in Kanawha County where one family court judge was just dedicated to domestic violence, nothing else. Why can't there be something like that on a regional level, on a state basis, but a regional level, within the budget? It could be a budgetary thing rather than have to have an amendment like you would for the appellate court. And you're going to have also the truancy courts involved in that. So that budgetary process is opening some doors that are heretofore closed. I don't know.
I have a faith in the voters as far as what their will is, all of the elected officials. If there's issues with the budget, I hope there would be retribution by one party or one part of government against the other. But if there's more transparency, I think the voters can see that as well. So if you have a budget, one item that's getting cut, voters will see that. They make their decisions in the next election.
I don't have a problem with the amendment. I think this particular court has earned the right to lose control of its budget. But I don't worry about the legislature controlling the court by budget. I think they found a brand new way to do it. And it's frightening to me. I mean, that we now have impeachment as a tool of control. So I don't know what kind of road we just went down. No other state in the country has ever impeached their entire court. And that's a frightening thing. When we start having amorphous reasons for impeaching somebody.
There's population shifts going on within the state of West Virginia. We need to look at, do we need to reorganize our circuit courts? Not to 2024. But we sort of can't do it between election cycles. That may be something that needs to happen. We
make adjustments from time to time. I don't think that's a huge issue, but you're right, the population issue that you have to hear about when you're applying the resources. But at the end of the day, this is the politically unpopular answer. We've organized circuit courts, but we still do filing by counties. And if you start to address whether you need to change that system, then you're going to run into a buzzsaw political opposition at the county level. But it may be that the clerk's offices need to be organized by circuit and not just by county.
But there's a federal constitutional element to that. The case came down in 1962 called Baker versus Carr, and one man, one vote. If you don't remember that case, there's federal courts that held subsequent to that case. It came out in 1962 that applies to the legislative aspect of government, but it doesn't apply to the judiciary. One man, one vote principle, which is constitutional in nature. And some people say that decision rivaled around this Board of Education in Kansas had its impact, but we don't hear it cited that much. In West Virginia, we do have a logistic problem, I think, or it's hard to justify it anyway. You've got McDowell County that has one judge with its population.
Now it's two.
Now two? Okay. That may be true. But still, the population is inverse to the number of judges, and maybe in other counties, there could be there is a great deviation. Nicholas County has one judge, and I don't think that's changed. But then, you have like two judges in the 4 counties of Braxton, Clay, Gilmer, and Webster. So, there is a great disparity, but I don't think it would be addressed on the constitutional thing. It'd be more logistic things.
We've done a pretty good job, actually, of assessing the workloads of the different circuits and different circuit court judges. One thing they didn't do, they broke it down. Let me take it back. They broke it down by circuit. They didn't break it down by individual justices. And the work that's required in Berkeley County might be different than the work that's required in Mason County. There might be more cases filed in one than the other. There might be different types of cases and things of that nature. Supreme Court's done several studies called workload assessment. They're available on the website. And the legislature has adopted some of those, and they've created new judgeships in different places. Now, they've never took away a judge yet.
That's right.
And there's probably some populations decreases in certain counties that might require that in the very near future. That is something where I hope the legislature, when they do it, I hope they look at more than just the population, because the population doesn't always determine the workload of the individual justice or individual judges. Sometimes there could be like Kanawha County. Kanawha County actually needs more judges than based on its population because it handles a lot of appeals to state agencies or things of that nature, and that's factored in. And there could be certain areas of the state that's hit harder by the drug epidemic than others require more. So I agree the legislature should look at it. I think they should look at it more than just population.
The reality is you'd never take one away, ever.
Access to the courts is absolutely critical, and whatever that's cost may be, but it does need to be balanced. We've looked at it through the National Conference of State Legislature, state courts. They do studies, weighted studies, different studies, but I agree with the judge and others have mentioned that, there are some cases are more labor intensive, abuse and neglect. The drug epidemic that we've had now in the state has led to significant cases for abuse and neglect and taking children away and placing them in homes with grandparents.
Guardianships,
things of that nature. Those are difficult cases that have to be, they're very time consuming. So you have to take a look at the weighted average, but one of the functions of government is frankly to provide free and open access to the court. Whatever the cost may be, you've got to be, judicious in how you spend it. But my goodness, people have disputes. I'd rather settle them in a courtroom than in a duel. That's why you have courts, and they need to have access. And because of our geographic barriers and different things we have, and lack of internet and things of that nature, it may be difficult to cover. You have a 4-county circuit, and be there every day. But as we evolve and grow the information technology and e-filing things, there's things that can be done, conferencing perhaps as well, where you don't have to drive 3 hours to the next, or an hour and a half to the next, an hour and 45 minutes each way to go to a hearing. And the judge could maybe sit there in a video conference, and they do it with, arraignments of inmates and things of that nature. there's no reason why we couldn't evolve with technology to make our judicial system more cost effective, but also to ensure access.
Access is constitutional, state of West Virginia, Article 3, Section 17.
And the 14th Amendment to the federal constitution also requires effective access, not just access, but effective access.
Y'all have anything else?
I've got one more question to wrap it up.
Well, we could ask Jor's question.
That's what?
Jor's question.
Okay, yeah,
Let's
go
do
ahead.
that.
Yeah, let's do that.
Okay, so yesterday we had this, Estonian?
No, Ukrainian.
Excuse me, Ukrainian, exchange student, high school student, and sat in and he asked the candidates from the other division, in your practices, what is the most common type of case you see, and what is the solution to that problem? We were quite dazzled by that question. So where do we want to start? Are you ready?
Yeah, I'm always ready.
Okay.
Well, to me, the most common case I saw in my practice of 39 and a half years before it came in, domestic relations. It's always domestic relations. That is divides the bulk. Now, I know that's a broad brush, but anything that has to do with the family, which is nothing more important than children, that's the type of numerically superior case that you see. And I think next to that, when I was practicing, you would see, believe it or not, a lot of workers' comp cases.
But the tricky part is, what is the solution to that problem?
And how does that help you seeing those cases that you saw most
Well,
often? How does that help you be a justice? Let's go on the line.
You want to finish that?
Go ahead, finish, and then let's
Okay.
go down the line.
Well, I think seeing those types of cases is we have to consider the opioid crisis and the breakup of the family, the abuse and neglect. We have to have more money allotted, and that can be in the Supreme Court budget too for guardians ad litem. Okay, we have to, I think legislatively, not as a justice, we have to get more money simply to DHHR for CPS, Child Protective Service hiring and retention, paying them a decent salary. But also, I think too, to attract people to sit where I sit, our salaries are statutorily the lowest in the nation and its possessions. We're lower than Puerto Rico in the family court setting. And as a result, sometimes we have people attracted into that haven't had a prior experience. Of course, we have that Supreme Court do, but they don't have prior experience. I mean, it's at least one justice on the Supreme Court probably has more hours in a culinary classroom than it does a courtroom. So I think we have to get a competent experience in those positions. Not so much what's the episode of Judge Judy and that kind of thing. Judge Judy justices.
Discuss it real quick.
Well, I think clearly, I think domestic relations and criminal charges and criminal cases surrounding the opioid addiction epidemic we have in the state. I prosecuted for 16 years, and I can tell you that it was apparent to me that the overwhelming majority of the people, probably 80% of the folks coming through that system, usually had a drug or alcohol addiction problem. And that's what led to their theft. That's what led to their problems at home. And that trickles down to frankly, to the family when you're having abuse and neglect cases, when you're having, what are the solutions? You need to have effective drug courts. I applaud Judge Douglas for his excellent work in that field, but I'm also proud of the fact that I created the first drug court and funded the first pilot project with Marty Gone up in the first district. And, no one had ever done anything like that before. Is it necessary? Yeah, it's now been replicated throughout every other 55 county in the federal system. Quite frankly, when I created that program, I didn't know, had no idea that I might need it myself. Because my oldest son became an opiate addict and was the first successful graduate of the federal drug court. But I can tell you this, I've seen those kids, and I've seen their eyes, and I've seen the problems that they have when they first go into scared treatment. They want to get well, they don't know how, and they can't. So it takes some medical intervention, quite frankly, and then it takes ongoing counseling and assistance and oversight from judges such as Judge Douglas and good counselors to make it work. And that can happen, but it's expensive. But boy, I work like the Dickens to save my son, and I work like the Dickens to save every other kid in this state as well. I think it's imperative that we continue those appropriate funding, the drug court programs and other intervention programs.
You do, Judge.
Somebody say.
I'll
Get
take
credit.
I'll take credit. I'll take credit.
Judge, I'm sorry, that's Thompson.
You remember the question?
I do, thank you. I also do a lot of domestic relations as far as custody and also direct landlord. Until we start to cut back on the Supreme Court. And there we try to find a solution, is try to do what's in the best interest of the child. So that's our hallmark, is what we try to shoot for. On the criminal side, wherever I've prosecuted or defended, so it's part of the committee for Elbrook or Johnson County. I'd say it's more like 90% of the issue is probably drugs. I know we throw a lot of resources in the state to try to solve that. I don't think we've found a solution yet. Maybe we try. And it hurts, I think, everyone up here to see people going through, the families to go through a lot of problems. It goes back to the family level. Those are the issues we're trying to correct as a society.
Yes, I will see that microphone. I will, so sure.
Sorry.
That's a great question, actually. Most of my 22 years of practicing law has been in the area of workplace disputes. So my issue usually boils down to one thing, is fairness and the perception of fairness. I have employees that I've represented who feel they've been unfairly terminated, and then I've represented employers who feel that they've been unfairly accused of wrongful discharge. So it all boils down to this notion of fair treatment under the law. And usually how I resolve these issues is because I've dealt with both sides. I typically will sit my client down and give them kind of like a third eye view of the situation, how this can be viewed from the outside. I take both sides of this work and listen to their story, and then tell them what the law is and tell them how various factors could come into play that would maybe not be in their favor. And my goal always, regardless of who I'm working with, is to tell them what the law is and listen to the facts and tell them how the facts can affect the outcome. And I always try to get to the just result the first thing. I try to figure out how we can bring both parties together and achieve a just result, one that both sides can stomach and both sides hopefully they would like, but sometimes the best result is the result that both sides don't like. But my goal is always first justice, and then at that point, if it doesn't work, you go forward and you base your case on the law. But I think what I bring to all of these issues is that I have a very kind of gestalt worldview. I look at all facts, so I'm able to consult my client on those.
I think I've already indicated the most common case I see are cancer cases of worker injury. I represent families and workers. And mesothelioma has developed into, I guess, my specialty over the last 20 years. So I'm dealing with usually families. It's not uncommon for me to represent a man who at 64, 65 somehow seems to be the age. He's 64, 65 develops mesothelioma. And there's usually, if there's one brother in the union, there's like three of them. And one may be a witness for the other one. Comes in at 64, he develops mesothelioma. And then the youngest brother is now the witness for the middle brother, and he develops mesothelioma. The most common cases I'm seeing now are housewives and children, bankers, who never worked with the product before, but the dad worked at Carbide or DuPont, and they brought him in. Every case that I deal with, I'm dealing with a family at its worst, a family who's dealing with one of the worst circumstances they've ever dealt with. But I'm also dealing with 20, 30, 40, 50 defendants. And my job is to balance that. I think I've built a reputation over the years with the courts and with my opponents, defense lawyers, that if they come to me and I don't have them based on the work history, based on where they were, I don't have you at this site. They're out. There's no excessive pleadings. We work together. And then when I come to the court with a particular defendant and a particular plaintiff, I've rarely been doubted by the court that we need a trial. We're just not going to come to it. So I think what I bring to the court is a view of looking at both sides and understanding the concerns of a defendant corporation not wanting to spend money on a case that doesn't belong, but also a plaintiff who's saying, I need a trial date, we just can't come to an agreement. My fear is everything we've been talking about, money coming in, judicial hellhole, the whole concept is to close the doors to the courthouse. Jeff Kessler mentioned that the courthouse doors need to remain open. My fear, representing people in West Virginia, because I know for a fact that this year there'll be a large number of housewives who get mesothelioma, and I made it in my clients, that children age 40, 50 will receive mesothelioma, and the courthouse doors are closing on them. And I trust the jury system, and I trust the legislature to make the laws. I will not interfere with the legislature, but I also won't interfere with a jury unless I think they're clearly wrong. Nor the legislature unless I clearly think they're wrong. I want to keep the courthouse doors open so that people can have access to the courts, and I want to make sure all parties feel like they're not on the menu.
Oh, I'm sorry. I'm good. The question started off as, what's the common issue you see in your cases? The answer, I do a lot of bankruptcy work, but I think this is true elsewhere. It's poverty. It is a lack of resources. It is a lack of respect for education. It's a lack of education people have. Poverty begets idleness. Idleness begets drug abuse. And I certainly don't want to minimize the scope of where I see drugs impact. But even in bankruptcy cases, I see a lot of people, particularly older widows, come in front of me, and everybody who's trying the best that they possibly can. I make a few criminal referrals every year for people who try to cheat the bankruptcy system, but mostly that's not true. Mostly people have respect for the system. Mostly juries try very hard, and I've looked at jury verdicts over time. Juries try to do the right thing. I think we are all committed in a social way to trying to do the right thing. But poverty is grinding, and it causes people to not take advantage of the situations they're in. That causes people not to seek the advice they should get. One of the frustrations in that area of practice is that people make a few more bad financial decisions. They'll refinance their house. They'll spend out their retirement money before they'll come see a lawyer who could undo some of those things or could prevent them from doing some of those things. The law works in their favor, but people try very hard to pay their bills because that's what they think they should do. So I think that I don't really have a solution for poverty. I'm not sure that the court system is going to do that. But I do think that the court system can appreciate that people who come to court not having put their best foot forward and having tried to do something and listen to the explanations that people have, because that's how we've built the law over the years, is listening to people and incorporating what most people think, and that really is what the rule of law has become. So it's not a perfect solution, but I think that's the problem, and I can solve that with more money, but I'm not quite sure that that's a really convenient political solution in this context.
First of all, I think it's a great question. The most common case I see now are abuse and neglects. Say at least 25% of my docket, if not more, is about neglects, which leads into the foster care crisis. When I first started as a lawyer, I would assign a lot of abuse and neglects as I was a young lawyer in Madison. We did probably about 25 to 30 abuse and neglect cases a year. They were more typical of poverty, they were more typical of mental illness, lack of ability. We had some really mean parents, things of that nature. Last year, I did 175 cases. Probably should have done 500, but we had to triage just because the system's so overwhelmed. And I do have a solution to that. I have tried for the last several years to get what's called a family drug system started in West Virginia. I've requested numerous times through the probation office, through the Supreme Court, trying to get it. I've learned a lot going drug courts. Did not go to college to be a drug court judge or anything of that nature. However, I have learned a lot. I've learned a lot of things that work. And I've learned that the more intervention the court has, the quicker you get people to treatment, the more hands-on interaction you have with participants, the better chance you have. Our most precious commodity right now is our next generation. We are losing 7,000 kids right now in foster care, and I think that's a gross underestimate. Because that does not count the number of kids who are not involved in the court system or being raised by grandparents or aunts and uncles and things of that nature. So I would say it's probably closer to 20,000 kids who are not being raised by their parents. We had family drug courts that would also give a quicker resolution, and we could get the parents into treatment and try to rebuild a family. However, most of the abuse and neglect cases I have are where the parents simply give up. I had a recent, I average probably 35 to 50 abuse and neglect cases. I set them all on Monday. That's all I do on Mondays. And if I have 50 kids, there should be 100 parents showing up. If I have 10 parents showing up, that's a really good day. If I have 5 of them show up that are doing what they're supposed to, that's a great day. And that doesn't work. The system we have, we're trying to put square pegs in round holes. We need to completely revamp it. Some of that's going to require some legislative intervention. A lot of that's going to fall on the Supreme Court. And we're failing our kids right now. We're failing the next generation. Some of the judges I've spoke to saying we became nothing but termination mules. I have trouble now trying to get parents served. A mother will come in and give birth at a hospital and disappear. We have to serve them by publication. And so that is the biggest problem I see. The solution to that, at least, would be the creation of family drug courts.
We see the arm of that.
Issues of substance abuse and the opioid crisis affect every aspect of my practice. You know, when you think of civil rights cases, you don't generally think of substance abuse. But the fact of the matter is that issues associated with substance abuse put police officers in untenable positions many times. They put officers in positions where they need to escalate through the use of force continuum in a way that they wouldn't ordinarily have to do. What does that do? That leads to use of force incidents, which then leads to questions as to whether that use of force was authorized. From the perspective of just the person on the street, they don't know whether the law enforcement officer they're dealing with, whether they can trust to that law enforcement officer's experience. That's a lot of where these cases associated with civil rights claims come from. Is because this crisis has so invaded every aspect of our society that it's causing us to question even how we relate to the authorities that we've put in place. When you have an injury case, what do you do when your client comes to you and you see that your client is on these opioids? You can't second guess the doctor, but you kind of have to. You have to step in and say, hey, client, you're on these drugs. You've got to really be careful. Now, I had a case not too long ago, a very, very well-established gentleman in Parkersburg. He was in his 60s. He had a horrible malformation as a result of birth injury. Had it all his life. He'd been on opioids for most of his adult life. They became less and less available to him. So at that point, he's in a crisis. How does he manage his pain without these medications? Our legal system has to account for these things. His honors programs, I would agree with him 100%. They're exactly what needs to happen. But it needs to be broader. At every level of our judicial system, where there is interaction with someone in which their circumstance has been affected by a substance abuse issue, that's an aspect where the courts can at that point intervene. Whether it's criminal, whether it's truancy issues, whether it's abuse and neglect cases, the courts have got to begin stepping forward and taking a proactive approach to not ignore these issues, but look at them as real causes and try to help. Thank you.
Thank you all very much. That concludes our. Oh, we're still on.